Hey everyone, today's video comes straight from the Nkabinde Inquiry, and things get intense. Advocate Shamila Batohi, the head of the NPA, is questioned by the lawyer representing suspended DPP Andrew Chauke, and the exchange gets heated very quickly. Both sides push back hard, and the room becomes tense as they argue over procedures, evidence, and accountability. It's definitely one of the most dramatic moments we've seen in this inquiry so far. Before we get into it, make sure to like the video and subscribe for more updates. Now let's get into the footage.
Yes. The third one is, on what basis do you say it was Advocate Chauke who attempted to have the charges reinstated? Just show me the document where he tried to do that.
I'm trying to recall the evidence of what Advocate Chauke did after Advocate Ngasana was appointed. And I can't recall it at the moment, what exactly the evidence is in that regard.
You can't recall.
I can't recall what the evidence is in this regard.
Yes, I understand. But it's unfair to ask you to recall all of the evidence.
Thank you very much. I appreciate that.
I can ask you to recall at least one thing, which is, on what basis did you suggest that it was Advocate Chauke who attempted to reinstate the charges? Surely you must recall that.
I can't recall what his conduct was at that point regarding what happened when, but for the appeal aspect, I'm not sure what more Advocate Chauke did. What I do know is Mr. Ngasana at some point asked Advocate Chauke, after he raised the issue of him exercising, well, I'm not sure how it was exactly put, but the fact that Advocate Chauke had no jurisdiction in KZN, and he then said that this matter must be dealt with by Advocate Noko. That's what I recall. So I can't, besides that, I don't know what exactly he would have done to have these charges reinstated after Mr. Ngasana was appointed.
Yes. Because it seems
if there's
to me,
any evidence, it will speak for itself. As I said, I'm testifying about things that happened when I was not even there. So it's about the evidence that should speak and not my trying to recall what the evidence was. That's what the idea of this fact-finding is.
you see, Advocate Batohi, it seems there are two independent acts that are being conflated. The first one is whether there was ever any attempt to bring life to these charges under Advocate Ngasana. The second is whether Advocate Chauke was involved at all.
Mm-hmm.
As I understand, you can't help us on either.
I can't, but hopefully the evidence leader can look into this, and if there's any evidence that needs to be led, any facts that needs to be brought to the attention of this panel, it will be done. If there isn't anything, that's the position.
Can you recall when Advocate Ngasana assumed the office of NDPP?
No.
If you go to LO 00886,
Advocate Ngcukaitobi.
thank you, Madam Chair. LO 00886. There is an email of the 11th of April 2014 at 2:51 p.m. from Mr. Chauke to Dr. Ramaite. Can you see it?
See one at 3:20 to
Yes,
51.
there is one below that.
To Dr. Ramaite.
Yes.
Yes, I see that,
Now,
251.
Mr. Chauke says, I refer you to the comments and reservations of both the NDPP and yourself regarding my involvement in the Cato Manor matter. I refer also to a subsequent meeting that I held with the NDPP on 8 April 2014. I hereby confirm that I will no longer take part in any way regarding the management and prosecution of this matter. I have accordingly informed the team leader, Advocate Mayema, and the DPP KZN Advocate Noko. That is dated the 11th of April 2014, referencing a meeting with Advocate Ngasan on the 8th of April 2014, where Mr. Chauke says he will no longer participate in any manner whatsoever on Cato Manor. So surely your evidence on 3.1.1.5 must show us that after this date, Advocate Chauke attempted to have the racketeering charges reinstated.
As I said, I'm not the only witness in this matter. I don't know what the evidence is going to show.
Well,
Please repeat the question, and if you can just try maybe to confine yourself to the question that has been asked. If you know, yes. If you don't know, no. So that we obviously know your stance about this question.
yes.
Because I'm not sure how you are answering it, Advocate Batohi. Please repeat the question.
Thank you, Madam Chair. Advocate Batohi, I referred you to the email of the 11th of April 2014 at 2:51 p.m. written by Advocate Chauke to Dr. Ramaite, in which Advocate Chauke says, bearing in mind the discomfort of the NDPP, which was expressed in the meeting of the 8th of April 2014, he withdrew from involvement in any manner on the Cato Manor case. Now the question is, surely to establish 3.1.1.5, you would need to produce evidence that after the date of the 8th of April 2014, Advocate Chauke attempted to have the charges reinstated.
My response to that is I don't need to produce the evidence leader needs to. I will testify about what I know, what evidence there is. I don't know what happened after that.
All right, let me not say you need to. Let me ask you, do you have the evidence?
As I sit here, I don't have any evidence.
All right, thank you very much. Could I then try and do an analysis of the following charge?
Just for clarity, and it is the evidence in relation to the alleged attempt to
Yes.
reinstitute
Yes, Madam Chair.
the
Correct.
racketeering charges.
Yes, correct. Now, could I also just try to analyze 3.1.2? That is the Mr. Mdluli charge. Now, could I just understand the scope of this charge again? Now, I'm going to reference a discussion that you had with panel member Ramaphosa. When she asked you about the charge, particularly with the use of the word "in that" as suggesting a limitation of the scope of the charge, you said in your response, maybe these terms of reference must be amended. Can you explain why you said that?
I can't remember the context of that particular question.
You
Let
can't
me
remember.
read this and see try to gauge what I might have meant by that. To the extent that this is not complete in terms of the conduct of Advocate Chauke's that we complain of, I would have possibly meant that it should be amended to include his conduct not just at the point of withdrawal of the charges initially and submitting it to an inquest, but also his conduct after that, after the inquest hearings, not hearings, yeah, they were hearings, after the inquest process was completed, his conduct in then not in accepting, well, not accepting, his conduct in coming to a conclusion that the magistrate found no evidence implicating General Mdluli when that was incorrect. The magistrate's findings were confusing and contradictory. So in that regard, Advocate Chauke at that point ought to have reconsidered the matter, given two things. One is that the prosecution team said there was strong evidence against General Mdluli, the fact that the magistrate's findings were confusing, and also the fact that the representations of General Mdluli was a fanciful conspiracy. So that's the next point of decision making. Thereafter, Advocate Chauke's conduct after the Mdluli, the Murphy judgment, when Judge Murphy was very critical of the conduct of Advocate Chauke and
Was uncertain about the strength of the evidence. Is it your case that a prosecutor does not need to be certain about the strength of the evidence?
that's not my case. That's what Advocate Chauke says.
No, I understand that his justification is that he was uncertain. I'm asking you why he is being charged. Is he being charged because you are saying a prosecutor does not need to be certain about the evidence before they enroll a matter?
That is not the reason why he's being charged.
But what is your answer to my question? Are you saying that the prosecutor does or does not need to be certain about the evidence before they put the matter for a charge?
A prosecutor must be certain of the evidence.
Yes. Now,
Perhaps, Counsel Advocate Batohi, are you suggesting, as regards the evidence that is to be presented at the trial, at the state of charging, a prosecutor must be certain of all the evidence that needs to be presented to prove the charge? Is my understanding correct? Or should there be merely a prima facie evidence to institute that charge? If you can clarify that to me, or clarify your answer to Advocate Ngcukaitobi.
Person, yes, thank you for that question. I'm not suggesting that at the point could in fact be prima facie evidence. It could be a situation where a person has been charged because there's sufficient evidence to charge, but at that point you should be certain of that level, whether it's prima facie, you must be certain that you have sufficient basis to charge the accused at that point. It doesn't mean that it will be all the evidence, because investigations could continue and more evidence could be gathered. So, but I think the question that I was answering to Advocate Ngcukaitobi was slightly different. My understanding of his question is that if a prosecutor, well, put conversely, is uncertain of the evidence, should you charge? And my answer to that was no, you should not.
Thank you.
Thank you. Well, it seems you've given inconsistent answers to my question and the chairperson's question, which are effectively the same question. Maybe let me give you a chance to clarify. What should a prosecutor be certain about? What is he allowed to be uncertain about before he makes a decision to charge?
Well, firstly, let me say I have not given inconsistent answers. I've answered different questions. And to your question, and the record will show, we can go back. Your question was, put conversely, whether a prosecutor should enroll a case if he is not certain of the evidence. And I said, no, that should not be the case. The chairperson's question went further and asked whether at the stage of charging, a prosecutor must be certain of all the evidence, and whether shouldn't there be a prima facie evidence. And my answer to that was that when a prosecutor charges, they need to be certain that at that point, it meets the standard that is required for the enrollment of a matter. That could be either at the level of prima facie evidence, which is completely in order for you to enroll it, but that doesn't mean you are certain of all the evidence, because there could be evidence that is obtained after that. So I hope I'm clarifying. In my view, I'm not giving inconsistent answers because the questions were slightly different.
Yes, thank you very much. Now, could I also ask you about the issues in relation to the Mr. Mdluli matter? Is it correct that you relied exclusively on the memorandum by Advocate Gauteng SC?
That's not correct.
What else did you rely on?
Prior to me asking for his opinion, I had received the opinion of Advocate Nalane, who recommended that this be one of the matters that be included in any referral to the president. I had Advocate Chauke's response to that in his in the form of Advocate Maineche's opinion. I think I must just look at my letter that I sent to Advocate Chauke before I respond further, to make sure that I am clear that my recollection of what happened a couple of years ago is correct. The letter to, is it in here? Okay, might be an attachment to my affidavit, Chairperson.
Is it when you requested Advocate Chauke to present further information?
On the 5 matters.
I beg your pardon, may I finish?
My apologies.
In a document attached to your affidavit, SB6, at 240, and I'm not sure whether this is a document where you requested for further information relating to the decision made by you as the DPP Gauteng Johannesburg, and Advocate Chauke then responded from SB 6241. Is that a document?
Yes, I think it's SB5, Chairperson. Just check that now.
You see, the one that I'm referring you to, just let's deal with the one that I'm referring you to first. That one is SB 6241, attached to your affidavit. Those additional documents that you filed of record, and in the first heading, he deals with the Richard Mdluli murder case and the related charges. Is that the document you wish to refer to?
No, Chairperson.
Okay, let's look at SB 5 that you referred us to then. Only SB 5 that I have here is your request to Advocate Chauke, SB 5231,
That's correct.
which then culminated in his response at SB 6.
That's correct.
The SB 5, is that the one that you're looking at, your request to him?
That's correct.
Yes.
I'm looking at paragraph 2 on page 232. So I had access to documentation in a file. I had a 2.2, there was a decision, a court decision. In fact, there would have been all the decisions. It would have been the Judge Murphy decision as well as the SCA Brandt decision, as I set out. So I would have had also Advocate Chauke's response to this matter in SB 6. I think that's all the information I would have had. That's the information I would have had before the opinion from Advocate Hully.
Yeah, we noticed that it's now past 12 o'clock.
It's 12:03.
Yeah, it's past 12 o'clock.
Thank you for reminding us, because I cannot be late for my appointment.
I had actually thought that maybe I should find out, Council, whether you are ending it up at General Mdluli's point, the terms of reference 3.2, or you want to exhaust this question before we step out?
Chairperson, may I please comment on that? Well, let's hear what Advocate Ngcukaitobi says first.
That's fair, because I'm asking him the question, not yourself. Shouldn't you wrap up, or you want to tie it up?
Madam Chair, I can stop now, but it's not a convenient place, but the agreement was that we would cut off at 12, so I should stick to that.
Advocate Batohi, as Council mentions, it may not be a very convenient point to leave the questions hanging, but given your request, we will, I see you anticipate what I'm going to say. We'll definitely adjourn because we bear in mind your earlier request that you be afforded an opportunity to go and attend to your personal matter.
Thank you, Chairperson.
So you need not change your face because.
Thank you, Chairperson. I'm only human.
We are going to adjourn to keep our undertaking to enable you, as per your request, to adjourn now until Thursday morning.